everybody. Welcome today. My name is Liz, and I'm a paralegal at Lyles Parker. Welcome to today's webinar entitled Data Privacy Issues and Regulations, HIPAA and Beyond. Today's webinar is hosted by the Texas Association for Home Care and Hospice, TAHCH, so thank you for that. And today's presenter is Heidi Kocher. And before we get started, I'm going to give you a little background on her. Heidi Kocher, sorry if I mispronounced that, is a partner with Lyles Parker. She has over 25 years of experience advising and defending healthcare clients on legal and regulatory matters affecting providers of all sizes. She is an expert in all aspects of compliance and privacy programs, including developing and deploying policies, procedures, and training. Her experience also includes serving as a Chief Compliance Officer and a Chief Privacy Officer, implementing the various requirements and aspects of corporate integrity agreements, and responding to and defending audits from Medicare, Medicaid, and private insurers up through the ALJ level. She received her JD from Georgetown University Law Center. She is licensed in Texas and Maryland and admitted to the U.S. Court of Federal Claims. And she's also a certified healthcare compliance officer. And without further ado, Heidi, I'm going to pass it over to you and we'll get started.
Thank you, Liz. I really appreciate it. Happy New Year to everybody on the call. One little bit of thing, I am at the tail end of some kind of weird upper respiratory infection, and I find that I occasionally go into a little bit of a coughing fit, so I may mute myself for a minute so that I don't cough like mad into everybody's ears who is on the call. But other than that, let's go ahead and get started. This is a topic I love. I love all these data privacy and security issues, and I hope this is going to be very useful to everybody. The little bit of a disclaimer, this is general information and educational information only. It does not constitute legal advice and should not be substituted for seeking your own legal counsel. We are attorneys, but we are not your attorneys, and outcomes may differ depending on the facts. So with that, let's go ahead to the next slide, please. So here's a little bit of an agenda and an outline. I just want to give some background as to why all of this is important, and then we're going to talk a little bit about the HIPAA security rule. I'm not going to touch really that much on privacy. I think everybody knows what privacy pretty much is, but I really want to focus more on security and the breaches. And then I want to talk about some ongoing initiatives with the right of access and information blocking, and social media, which is always, of course, a big topic among healthcare providers. And then I'm going to touch on the future of HIPAA, and then we're going to talk about some compliance tips at the end. Next slide, please. So why is this important? Well, as of October 31st, you can see that OCR has received almost 345,000 complaints of privacy violations since they started tracking this. That is a whole lot of complaints. They've been tracking this for a number of years, and again, it's probably, I'm trying to remember when they started tracking it, probably about 10 years, maybe 13 years. But as you can see, there are thousands and thousands of privacy violation complaints filed with OCR every year. And the regional offices have staffs dedicated to just doing intake and sorting through the investigations. Our regional office here in Dallas for OCR, I think, has 4 investigators doing nothing but these privacy violations. The good news is that 67% of the complaints are actually resolved with fairly straightforward corrective action plans, and a third of them have absolutely no violation found. So that's good news to note. 138 cases were settled with monetary fines, which means that OCR really found some bad circumstances, or the companies just really did not cooperate. And surprisingly, there are close to 2,000 referrals to the Department of Justice for criminal prosecution involving the knowing disclosure of PHI. In calendar year 2023 alone, we had 546 incidents reported to OCR that involved 500 and plus individuals, and this is nationwide. And the reason that I wanted to really touch on security is that you can see that 83% of the incidents reported in 2023 were hacking or IT incidents, and another 14.5% were unauthorized access or disclosure. And when I pulled up the records on that, the bulk of those involve some form of electronic access, be it a network server, email, or an EMR. So as you can see, if you add those numbers together, vast majority, 97% of the incidents that involved 500 plus individuals in 2023, 97% involved some kind of form of electronic data or electronic systems at issue and at risk. So the security becomes really, really important. Next slide, please. And as you will see here, this is also because, again, we have a relatively small number of cases that were settled with fines, but you can have financial penalties, and the fines are tiered, and they are also inflation indexed, which is why you see these weird numbers. So the first tier is where the covered entity or business associate committed an error without reasonably having known about the breach, and your costs there are, or your fines are $137,000 to $68,000, almost $69,000 per incident, up to a max of just over $2 million. The second tier is where the error would have been discovered if the covered entity or business associate had exercised due diligence, even though it wasn't willful neglect. And there your fines are, again, almost $1,400 to, again, almost $69,000 per incident, up to a maximum of $2 million. The third tier is where the covered entity or business associate acted with willful neglect, but corrected the issue within 30 days, and our fines there are almost $13,800, again, up to $69,000 per incident with a max of $2 million. And then finally, where the covered entity or business associate acted with willful neglect and failed to correct the issue. And this is just a flat out, almost $69,000 per incident, up to a max of $2 million. So you can see that these civil monetary penalties can rack up pretty quickly. Next slide, please. In addition to civil monetary penalties, there are potential criminal penalties also for the failure to comply. And these are also tiered. So your first tier is if there was a reasonable cause for the violation or no knowledge of the violation, you can get up to a year in jail. The second tier is obtaining PHI under false pretenses, up to 5 years in jail. And the third tier is if you obtain PHI and use it for personal gain, you can get up to 10 years in jail. It isn't too common to see criminal penalties, but they are out there, and I'm going to mention some cases coming on in the near future, a little further on. Next slide, please. So with that as a background, you understand why there is such a focus on HIPAA security. So one of the points that I want to make here is that the security rule was published in February of 2003. That means the security rule is 20 years old. I'm sure some of you who have children who are now in college who were born after the security rule was published. So just think about how long ago that is. I have the hyperlink there to the security rule if you want to read it in all its lovely detail. But because it has been published so long ago, the government really does expect you to understand what the requirements are and to have to meet its requirements and have the things in place that you need to be in compliance. So just as a quick summary and recap, covered entities have to ensure the confidentiality, integrity, and availability of all EPHI. And here are the magic words: create, receive, maintain, or transmit. So anytime you touch EPHI, you've got to maintain the security of it. Identify and protect against all reasonably anticipated threats to the security or integrity of the information. That's a very key one there. Protect against reasonably anticipated impermissible uses and disclosures, and then ensure compliance by their workforce. So those are all elements of the security rule. Originally, business associates were liable for these as well via a business associate agreement with the covered entities, but with the passage of HITECH and the implementation of the HITECH rules in 2013, business associates are now independently liable for these things as well, not just based on the business associate agreement, but they have independent liability for that. Next slide, please. Okay, the big thing with HIPAA is the security rule, and as we saw on the earlier slide, you have to, maintain the confidentiality and integrity of any information you create, receive, maintain, or transmit. And the way you achieve this, the really big thing, is to do a security risk analysis. And I put this here in red because it astonishes me how many entities have yet, 20 years after the effective date of the security rule, have yet to do a security risk analysis. And I'm going to tell you that one of the prime reasons that people are fined or get a corrective action plan is they have failed to do a security risk analysis. And it's fairly straightforward and it's fairly easy. I've put here links for HHS's Security Risk Assessment Tool and also for NIST, the National Institute for Standards and Technology. There's also 2010 guidance on the requirements of the risk analysis, and there's additional guidance material there, and these are all active hyperlinks. Now, risk analysis and remediation is a continual, ongoing process. And for certain providers, those that are MIPS eligible, so most of your hospitals and your physicians, they must actually be doing an annual risk assessment in order to be available or in order to be eligible for the MIPS bonus money that's out there. Now, the security risk analysis, you can certainly do this yourself. And again, there's the link to the tool there. This strikes me, however, as a little bit like mowing your lawn. Now, I have a lawn. I can mow my own lawn, but do I really want to mow my own lawn, especially in the heat of summer when it's all hot and humid? No, it's just easier for me to pay a lawn service to mow my lawn. If you're not going to do the security risk assessment on your own, and unlike mowing a lawn, this is not something that you can complete in half an hour. It does take a little bit of time. I think this is one of the things where you are very well advised to outsource it and to send it to somebody else who can do it and can send you the documentation and give you the report and perhaps even help you with some of the remediation. There are other companies out there that can do this. And if anybody is interested in any of them, feel free to reach out to me after the webinar. But really, it's just do the security risk assessment. If you have somebody do it, you're covered. And again, this is one of the big things. This is one of the first things that when you have a breach and OCR comes to investigate, they're going to ask for a couple of things. And one of the things that they are always asking for is the security risk assessment. And if you don't have it, you're already starting out at a negative position with them. So just do it. Next slide, please. So a lot of people ask, well, you know, okay, we maybe didn't have the security risk analysis in place, but we're looking at encryption. So talk to me about encryption. So encryption is technically not required by the security rule. However, with the state of technology at this point, it is the only way that you can achieve security in compliance with the requirements of the security rule. So even though they don't say you must encrypt your devices, it's really the only way that you can do it. And so I really think you should be encrypting all your devices, especially those that are used in the field. Then if you have a potential breach, and I'm going to talk about the 4-factor analysis in a little bit, but there's a 4-factor analysis that you have to go through to see whether it really is a breach. But if the PHI can't be accessed because it is encrypted, then one of your factors is very much in your favor, and it can favorably influence your 4-factor analysis in determining whether or not you also have a breach, even though you may have an unauthorized disclosure. I will note that approximately all of the settlement agreements and resolution agreements entered into by OCR involve the loss or theft of unencrypted devices. So besides just doing the security risk analysis, the other thing you should be doing is encrypting your devices. And again, here are links to OCR HHS guidance on rendering unsecured PHI unusable, unreadable, or indecipherable, and the NIST guide to storage encryption technologies for end user devices. The NIST guide is somewhat old and somewhat dated, but again, the principles are there and are useful, and they make very good reading. Next slide. So the reason that we have concerns about this is OCR continues to have significant concerns about what I call PHI out in the wild, right? And there's multiple instances here. I've just put 3 up here. In 2016, we had a DME provider, the regional manager. She kept patient files in her car and in her personal residence. And here, there was an unfortunate personal incident. She was having marital issues, and she moved out of the residence and left her husband. In December of that year, the husband notified OCR that he had found files under a bed and in a kitchen drawer. I guess she was working in the kitchen and had somehow forgotten that those files were there. And so he notified OCR that he had files relating to 278 patients. When OCR investigated this, they found that Lincare did not have any policies or procedures on how to safeguard PHI taken off the work premises. And Lincare paid almost $240,000 in fines in 2016. So a couple of things here. First of all, notice how long this took to resolve. And second of all, that's actually a fairly steep fine for 278 patients. And again, it just points out the risks for all of you who have folks out in the field to be really clear about having policies that address what kinds of PHI you have outside of the offices and how those are managed and how those are secured. In 2019, the University of Rochester Medical Center, they had a $3 million settlement with OCR and a 2-year corrective action agreement. And theirs was a failure to encrypt laptops and flash drives. The problem that Rochester had was that they had lost a flash drive in 2010 and notified OCR then. And then they had follow-up losses in 2013 and 2017. And basically, they had failed to learn from the loss in 2010. And in 2013 and 2017, they still had unencrypted flash drives and laptops. So again, a big problem there, and really points to the need to encrypt anything, especially a flash drive, if you're going to be taking it out of the offices. And a side note, query, are flash drives really necessary if people are doing work remotely or from home? There are other ways to manage it other than flash drives. North Memorial Healthcare 2016 had a $1.5 million fine after an unencrypted laptop was stolen from an employee's car. I have numerous stories about that kind of thing where laptops or other devices are stolen out of vehicles or homes, and they are not encrypted. And again, the covered entities pay significant amounts. Next slide, please. And I just want to put up here some other resolution agreements. Again, they kind of all, they may sound like they're privacy, but they're really, really focusing more on security. So you've got the improper disposal of PHI. They put specimen containers in the garbage bin in the parking lot, and the practice paid $300,000 and entered into a 2-year CAP. We had a business associate providing coding and billing services that had an unsecured server open to the internet. They paid $75,000. And again, here's an instance where they failed to conduct a security risk analysis. So they paid $75,000 and signed a 2-year corrective action plan. Hospital employees accessing medical records. This is not uncommon. There are lots of employee snooping cases, and they involve all kinds of providers, not just hospitals. And again, here the hospital paid $240,000 and signed a 2-year corrective action plan. And then we have examples of the hacking breaches. So Oklahoma State had a hacker install malware on its server, and it resulted in the disclosure of the PHI of almost 280,000 patients who were being treated through the Oklahoma State University system. The breach went undetected for almost 2 years. 2 years. And OSU was fined again for failing to conduct a security risk analysis, implement a security incident reporting system, and failure to provide timely breach notification to the patients. And they paid $875,000 in fine, plus a corrective action plan. So you can see that entities large and small are failing to do security risk analyses. And when it happens, like I said, OCR's first question is going to be, do you have a security risk analysis? Show it to us. And if you don't have it, you're in deep doo-doo, as these cases indicate. Next slide, please. I'm going to switch topic now a little bit and talk a little bit about the breach notification rule, because there are actually a lot of concerns with breaches. So the breach notification rule is at 45 Code of Federal Regulations, section 164.408, and again, there's a hyperlink to it if you want to look at it. And the security, or the breach notification rule says that an impermissible use or disclosure is presumed to be a breach unless the covered entity or business association can show a low probability that PHI was compromised based on an analysis of 4 factors. And those 4 factors are the nature and extent of the PHI involved, including what kinds of identifiers you had, and if there was any DI identification, what the likelihood is of re-identification. Who is the unauthorized person who used the PHI or to whom the disclosure was made? And if you have a hacking incident that is sometimes very difficult to determine. If you have ransomware and somebody threatens you with ransom, then you have a little bit of a better idea. Whether or not the PHI was actually acquired or viewed, and this is where your encryption comes in. If you're encrypting your data, then your PHI might not, that was open, might not actually be acquired or viewed. So that's why encryption becomes so important, and it can really sort of knock out this third factor. And then the extent to which the risk to any PHI has been mitigated. Again, there's ways to do mitigation. And remember that the time limit to notify patients under the federal HIPAA rule is 60 days. Next slide. The reason I kind of put this up there is because we have major issues out there with covered entities and business associates sending notifications to patients of a data breach and the reporting of data breaches to OCR. So I just put two examples up here. Presence Health in 2017 paid a $475,000 fine for a 42-day delay in reporting. 42 days is not a lot. It's basically, what, 6 weeks? Not quite 6 weeks? Yeah, so they delayed and went beyond the 60-day deadline and got hit with a significant fine for this delay in reporting. Centara Health in 2019 paid over $2 million in fines, and they failed to properly report the breach. So what happened with Centara is there was a patient complaint. OCR investigated. OCR said, you have a breach. We think you need to report it. So go ahead and report it to us formally. Well, Centara Health failed to do that, even though OCR had told them to file a breach report. And so they ended up with over a $2 million fine. So again, major issues with, with doing the security risk analysis and then notifying patients. Next slide, please. But it's not just the feds that are getting into this. The state attorneys general are also getting into data security and breach notification prosecutions. So Aviana Health in November 2022, this was a home health agency that had phishing attacks. They got over 600 emails in July 2019, and they discovered that some of the employee accounts had actually been hacked. In August is when they discovered it, of 2019. They notified affected patients in February of 2020. They had over 4,000 patients and employees' data exposed. The Massachusetts Attorney General said that Aviana's security program didn't meet the requirements of the Massachusetts data security regulations, which, like many states, pretty much track the federal regulations. So Aviana paid a $425,000 fine and was implementing a comprehensive information security program, which is basically a 4-year corrective action plan. So they're still in the middle of their corrective action plan. I will note that this breach also led to class action lawsuits by the affected patients. So it's not just the state attorney generals that are getting involved. Patients can actually sue under state regulations as well. Similarly, we had Retrieval Masters Credit Bureau, which was doing business as American Medical Collection Agency. They collected small balance medical debts. And between August 2018 and March 2019, they had a breach of systems. Excuse me. They had PHI of 7 million people total were disclosed, and almost 1.5 million Texans PHI was exposed. So in this case, we had 41 state attorneys general sue And AMCA agreed to a 7-year corrective action plan to implement information security programs, including the hiring of a chief information security officer, and they paid $2.8 million in fines. A couple of years ago, we also had Equifax. Texas, the Attorney General of Texas, collected $10.9 million as part of a nationwide $600 million settlement from a breach exposing personal information of almost half of the United States. And again, I think it was 49 state attorneys general, Washington, D.C., and Guam, I think it was, that participated in this nationwide settlement. So just be aware that it is not just the feds that are involved on this, but the state attorneys general as well. And here in Texas, our attorney general has been relatively active in some of these things. So I would not be surprised to see more of these kinds of settlements being announced, because these kinds of data breaches are just getting more and more and more common. Next slide, please. Going to change gears now a little bit and talk about some slightly different things. So one of the things that I want to talk about is the patient right to restrict disclosure, which is going to lead us into the patient's right of access. And I think these are two things of the same coin. So remember that under HIPAA, patients have the right to restrict disclosure of their PHI. It is okay to share information with family members if the patient doesn't object or if the patient agrees. Things that we particularly need to be aware of are disclosures involving mental health. There's always a question about, how do you know if the patient doesn't object? Well, if somebody walks into the room, let's say you have a field staff out there and, there's a family member there, and you want to discuss something, you can pick up on nonverbal cues, right? If the patient seems to be including the family member in the conversation, that's one way to know. It's always a good idea to just ask explicitly up front, do you mind if we talk about sensitive medical information in the presence of your family member, and get the patient's verbal consent? If the patient is incapacitated, always a mouthful, the provider can share information with family members if, in his or her professional judgment, the provider decides that the patient would not object and or such sharing is in the best interest of the patient. So again, it's going to be a fact-specific inquiry, a case-by-case decision if you have incapacitated patients. Remember that when you do share this information with family members, you should be only sharing the minimum necessary. So let's say you have a patient who is incapacitated. They have had hip replacement surgery and they need some physical therapy. And you get information from either the hospital or a physician that indicates the patient has had, let's say, mental health issues. Well, you don't know if the family member knows about that, so you should not be disclosing the mental health issues when all you're there is to provide physical therapy. So remember, you just want to be very cautious about what information you do disclose to family members. And you need to be training your staff on that. And again, there is OCR guidance out there on that. It's worth reading to just see what OCR says about this. Next slide, please. So the flip side of restricting disclosure is the patient has a right of access to their records. And OCR has received many complaints over the years that healthcare providers failed to promptly give the patients access to their records. And there is a a regulation here, 45 CFR 164.524, which grants patients the right to the access to PHI that is in the designated record set. And that's pretty much everything that you all will have in your records. The personal representative of the patient also has the right to access PHI if the patient is incapacitated in some way, shape, or form, excuse me, as well as instruct covered entities to transmit copies of the PHI to another designated person or entity. And a couple of years ago, because OCR had had so many complaints of this, they created this initiative, and they have actually prosecuted a whole bunch of entities. And as of the end of November, they haven't updated their page yet, but as of the end of November, we have 45 entities that are both large and small that have entered into resolution agreements and paid fines to resolve complaints that they have failed to turn over information to patients or give the patients the right to access their PHI. Now, many physicians are doing this with portals. They're allowing patients to access their PHI through a portal. That's not super common that I've seen in home health and hospice yet, and maybe we'll be going this way. But it's, again, something to be aware of when this crosses your path. Next slide, please. So, related to the patient's right of access, OCR figured out that many entities were doing what is called information blocking. And like I said, it's a corollary to the right of access. So the 21st Century CARES Act in 2016 actually authorized the OIG to investigate and impose new penalties for blocking. And the first set of rules was published in May of 2020, where they define the information blocking. So we have a few slightly different terms here. EHI is electronic protected health information, so basically EPHI. Note this doesn't include psychotherapy notes or information that is compiled for use in civil, criminal, or administrative proceedings. And they define information blocking as a practice that is likely to interfere with access to, exchange, or use of EHI, where the healthcare provider knows such a practice is unreasonable and is likely to interfere with, prevent, or materially discourage access, exchange, or use of EHI. There's a couple of exceptions, where you have an individualized risk of harm by a licensed healthcare professional. And basically, these are the same types of harm where you go through when a covered entity says, I'm denying access to PHI under HIPAA. So since these rules have been in place, so between April 2021 and September of last year, OIG received over 870 allegations of information blocking, 60% of which came from patients. And again, there's a limited amount of underlying data, but I suspect that this is from entities large and small, just as it is when you look at the Patient Right of Access Initiative. Next slide, please. So they published a final rule to impose penalties on health IT companies, and that was published back in July. And it includes health information networks and health information exchanges. They've published new draft rules for some health providers back in October. and they make, again, OIG the main investigative agency. These rules are currently only aimed at hospitals and MIPS eligible clinicians, so MDs, DOs, nurse practitioners, physician assistants, PTs, OTs, social workers, etc. HHS has specifically said that they will be expanding these rules in the future to other clinician types. So stay tuned. This will, I'm sure, be affecting home health agencies and hospices in the future. But basically, patients can report potential information blocking versus via an information blocking portal, and it's actually very easy to use. When OCR determines that there has been information blocking, then they can impose penalties. And for these MIPS eligible clinicians, it will be a denial that they are a meaningful user. And basically what that means is they lose any MIPS bonuses that they may be eligible for. They can also be removed from the Medicare shared savings programs, and that's like your ACOs where you get bonuses for meeting quality of care. So that's the penalties currently. These penalties are going to be published on ONC's, the Office for the National Coordinator for Health Information, ONC's website, and it will look similar to Office for Civil Rights' Wall of Shame for breaches of data involving 500 or more individuals. So these are moving apace. Information is out there, the information blocking rules. And I think these are actually potentially useful for you all in hospices and home health agencies. Next slide, please. And I'll tell you why. This next slide has screenshots of the information or the data received on the information blocking portal. As you see, there were 856 potential claims of information blocking. And this one below says that there, I think the numbers were 123 third parties on patient behalf, 93 by healthcare providers. So healthcare providers can file information blocking complaints. Where does this affect you? Well, one of the big things that I know home health agencies and hospices often get or have a problem with is getting information from either the hospital or the referring physician or provider. And so you can use an information blocking complaint to try to dislodge this information. And by doing this, what you end up is you start ending up getting the weight of the federal government behind your complaints. Now, I wouldn't use information blocking complaints as the first tool out of the gate. But if you have tried to dislodge information from another provider and you just can't get it, and you need that information to support the care you've provided and to support the claims that you are submitting, absolutely, I think you can use the information blocking rules and try to get the information that way. So just something to think about, and beware that these rules, again, will be extended to other providers in the future once they see how it works with hospitals and the MIPS eligible clinicians. Next slide, please. I want to touch briefly on Texas privacy laws. We have the Texas Health and Safety Code, Chapter 181 is our Medical Records Privacy Act. These parallel HIPAA rules, I know you all know this, but it's worth repeating. There are some differences between the Texas Medical Privacy Act, Medical Records Privacy Act, and HIPAA. And again, remember, if the state law is more stringent than the federal law, the state law controls. So new employees have to be trained on PHI protections within 90 days of employment, and that is for all healthcare employers. So you should be training new employees on HIPAA and the Texas privacy laws. Patients have to be given access to their ePHI within 15 days of request. HIPAA allows 30 days. Texas, only 15. One of the nice things is that pursuant to this law, the Texas Attorney General actually created a standard patient authorization form, and I forgot to put the link in here to that form. I think if you have patients requesting PHI, it makes sense to use the form that the Attorney General created, right? Because if you use that, you know that it's gotten review and blessing by the Texas state government. So that is one thing that I would recommend. And just if anybody wants a link to that, email me afterwards, or you can just Google it. The other thing is that their penalties are a little bit different. There's $5,000 for a negligent violation, $25,000 for a knowing or intentional violation, and up to $250,000 where PHI was knowingly or intentionally used for financial gain. So some pretty stiff penalties. Also, under Texas law, if you have breaches or fail to comply with this statute, you may be excluded from Texas Medicaid. And right, the way exclusions work is if you get excluded from the state, you are likely to be excluded nationally, which means Medicare, and then private entities, the private payers, may pick up on that. You can also have licensing actions taken. There is the provision in there. I'm going to cough here. Hang on just a minute. Sorry. Texas Attorney General can file a complaint and and start a licensing action against any licensed provider if there is a breach of the Medical Records Privacy Act. Next slide, please. Another thing that we have that is starting to come to the forefront is the Texas Identity Theft Enforcement and Protection Act. Note that this is not limited to PHI, but it includes sensitive personal information, and this includes certain identifying information beyond the standard PHI. Here, you have to report the data breach to the Texas Attorney General within 30 days if 250 or more individuals are affected, and I put a link to that in there. Once you've reported the data breach to the Texas Attorney General, you have to notify your affected individuals within 60 days. So this hasn't been used too much, really, at least not that is publicly available information, but I suspect this is going to become another tool in the state government's toolbox to prosecute breaches. Next slide, please. All right, social media. Moving along very quickly. Social media is a big issue, and CMS published a memo on how long-term care staff are using social media, especially photographs. Now, even though this applies to things like rehab facilities and nursing homes, I think the principles in this memo are quite useful, and I think you should all read this. So for social media, make sure you have a policy in place and have your staff sign an acknowledgement of this policy relating to social media. If you're doing any kind of photographing, such as a wound, please obtain patient consent and have your staff notate the consent in their records when they are doing the write-up of the visit notes. You want to limit distribution of PHI and especially photographs and use to the minimum necessary. Note that any posting of PAI requires patient authorization, and these provisions apply to personal social media accounts as well as corporate ones. So what you want to be doing is you want to have a way to monitor the social media channels. So just one example here, you can set alert for your entity names or hashtags or something like that. It is a big problem. I've dealt with multiple circumstances in the last, I don't know, 10 years, 15 years, where individuals have posted information either on Facebook or more recently on TikTok, and you don't know where it's going. And the funny thing is, this information usually isn't up long. Usually somebody sees it and says, hey, this shouldn't be up there. I had one instance where a physician's office, they were short-staffed, had a lot of people calling out sick. And they brought in a staffer from a temporary agency, and she was overwhelmed by the amount of work. So she actually snapped a photo of that day's schedule and posted it to her social media account. That was mid-morning. By 3 o'clock that afternoon, the practice had gotten a phone call from somebody who said, you have PHI being posted out there. So it wasn't even 24 hours. It was what, maybe 5 or 6 hours before this stuff was taken down. But again, fortunately, there weren't more than 500 patients involved. But we had to go through the entire process of making reports to OCR and implementing corrective action plans and responding to their requests for actions. You know, they had to do a whole new security risk analysis. All the staff had to be retrained. The policies had to be re-reviewed and rewritten. So it was a lot of work. So make sure you understand, you know, what your personnel are doing on their off time, on their personal social media accounts, as well as on the corporate ones. And one of the big ways that you can get into trouble is by responding to negative online reviews. People get upset, emotion takes over, and people inadvertently respond to that. Next slide, please. One thing to be aware of, the American Nursing Association Principles for Social Networking and the Nurse, they actually have ethics guidelines for nurses. And so these say that the nurse shall not transmit or place online individually identifiable patient information. You should understand that patients and other people may view the postings. Make sure your privacy settings are set to maximum. Should bring content that could harm a patient's privacy, rights, or welfare to the attention of the appropriate authorities, and participate in developing institutional policies governing online contact. Why do I mention this? Because boards of nursing typically look at what are called the standards of care and the standards in the community. And even though these principles and these ethics rules may not be formally utilized in Texas or another state's board of nursing, when they do an investigation, they will look to these as evidence of what some of the ethics are out there and as evidence of what community standards are. So nurses in particular are on notice of these problems. Next slide, please. This is just a slide with some OCR settlements involving social media use. We've got a psych practice that responded to a negative Google review and disclosed the patient's diagnosis and information about the treatment plan. And after that patient complained, the OCR investigation found that 3 other patients' information had been disclosed in response to negative reviews. The practice paid $30,000 in fines and had a 2-year corrective action plan. And remember, when you have a corrective action plan with OCR, you're submitting periodic reports to OCR. And just like if you were under a corporate integrity agreement, they have the right to come in and audit and ask for a request and information. 2022, $23,000 settlement for a dentist for his disclosures in response to online reviews. 2019, another online disclosure case with another dental practice for $10,000. In 2016, we actually had a CNA post a picture on Snapchat of an Alzheimer's patient who was wearing only a bra This occurred in a nursing home, and the patient, being an Alzheimer's patient, I guess was having a bit of a meltdown and refusing to, I don't know, get dressed or whatever. The CNA posted the picture on Snapchat for 24 hours, and then somebody reported it to the facility. The CNA was fired, and she actually spent 30 days in jail under that state's laws for the improper posting of PHI. So, you know, up on Snapchat for 24 hours versus 30 days in jail. I don't know about you, but man, I sure wouldn't want to spend 30 days in jail for a misplaced post on Snapchat. And ProPublica has published a report of 65 incidents, and this report only ran through, I think it was about 2018, 65 incidents of healthcare workers posting photos or videos of patients along with the consequences of them. So this is serious, and it happens out there. So again, make sure you really understand and have your social media usage under control. Next slide, please. Okay, almost done. Future of HIPAA. So one of the things that I want to put out here is, remember that HIPAA was enacted in 1996. My gosh, this thing is verging on, 30 years old. And this was before the internet really became as widely used and as many technologies as we have out there. The privacy rule dates from December 2000, the security rule from February 2003, and the high-tech regs from January 2013. We've had a lot of technological changes since then. So in 2021, OCR actually published a notice of proposed rulemaking to update HIPAA regulations. They received close to 1,400 comments in response, and OCR has said that they will publish a final rule sometime in 2024, updating probably the privacy rule. I don't know if they're going to go for the security rule. It seems to be more privacy rule focused, but I think we'll get new regulations in 2024 on the privacy rule. Some of the proposed language in here would expressly permit covered entities to disclose PHI to home and community-based service providers, home health agencies, and that's actually explicitly in the draft rules. I'm not sure why they thought it was necessary to explicitly single out home health agencies for this. Maybe they thought it was unclear that home and health agencies were healthcare providers. I don't know, but it actually expressly permits disclosure to home health agencies. And that's really good, because now we're going to be able to more easily point to these regs when you have issues with physicians and hospitals. And hopefully you won't have to go the route of the information blocking. It also has proposed language expressly permitting individuals to direct the sharing of their ePHI among providers, which is very, very important. And again, you know, I think if you guys have portals, this is the kind of thing that patients are really going to look forward to. And one of the big burdens I know out there is the stupid, oops, I shouldn't have made that editorial comment. The patient acknowledgement of receipt of notice of privacy practices. This has turned out to be an administrative burden with no discernible benefit. So one of the things is it would eliminate the need to obtain a patient acknowledgement. There's much more stuff in there, but they're working through all the regs and the comments and rewriting the regs. So we'll see what's published. But again, stay tuned for updated HIPAA regs sometime in 2024. Next slide, please. Okay, we've got some other laws that may impact you. The Federal Trade Commission has red flag rules to detect and deter identity theft. They haven't been used too much in most circumstances. They've been used with some billing companies and some of the larger healthcare providers like hospital systems, but beware that they're out there. The other thing is we have state laws on data privacy beyond HIPAA and PHI, and where these bring in where these may affect you is that they talk about things like the data that is collected outside sort of the PHI context. So for example, if somebody's using a wellness app like a Fitbit or an Apple Watch or something like that, these things would be covered by that. And if you are going to be using that kind of data, know that you will be covered by these as well. In this last legislature, we actually passed, and the governor signed, a Texas Data and Privacy and Security Act, which mirrors those other states up there. And this will be effective July 1st, and it applies to all companies conducting business in the state. There is an exemption for small business as defined by the SBA, which is less than $19 million in revenues for home health agencies. So I think unless you're doing more than 19 million in revenues annually, you probably won't be covered by the Texas Data Privacy and Security Act. But again, be aware that those kinds of acts start setting the standard for what you need to be doing. All right, next slide, please. To summarize, tips and best practices, you really need to know what the requirements are. You should have a person whose job it is to understand privacy and security, and you can name them a chief privacy or whatever. The problem that we have is that many smaller healthcare providers divvy this function up, and somebody does this, plus they do billing, plus they do marketing, plus they do, field supervision, whatever. Know who this is and make sure you have somebody who is responsible for this. Make sure that your policies are up to date and that you have the correct policies. Again, depending on what you've got out there, you want to have encryption policies, you want to have social media policies. There's a whole slew of policies that I'm willing to bet that most people don't have. Make sure you conduct a security risk analysis, preferably annually and after major changes of the breach. If there's one thing you take away from the webinar, it's do that. Train your staff. Remember, new employees must be within 90 days. We recommend that others be trained annually. Be ready for a breach. Have individuals designated who are going to respond and have a toolkit ready. Have the 4-factor analysis ready. Have people lined up who can help you with determining if data was exfiltrated or fixing a ransomware locked computer, whatever. Do your due diligence up front and have these lined out, because when you have a breach, the times start ticking very quickly and you do not have the time to figure out which company's proposal is better. So be prepared for this. It's like the disaster prep. Know what you're going to do if you have a breach. You want to monitor social media. You want to purchase cyber liability insurance. Make sure the coverage is sufficient. You need to read your policy. A lot of people think that their general malpractice liability covers cyber liability. Most of the policies that I've seen don't. You need a separate cyber liability insurance rider. Make sure you've got enough coverage. Some of the coverages are only, $10, $15, $25,000. If you have a breach, trust me, you're going to be spending more than $25,000 in responding to the breach. So make sure that you have sufficient insurance and that it will be triggered when you notify your insurance company. And finally, consider if you can use the information blocking rules to your advantage. I think there are some ways that some of these rules can be used to the benefits of home health agencies and hospices. Next slide. There is no stupid question in this arena. So if you are in doubt, please ask somebody who knows. We're available to answer questions and to help out wherever people can. I think attending webinars like this is very important because, again, it tells you what else is out there, what other alligators are out there in the swamp. That's our webinar. The next slide has my contact information. Please feel free to reach out. And again, I can send links to some of the information if people are of interest. Liz?
Yes, Heidi, thank you so much. Let me just see here if this question, we have a question here. I don't know if you can address it, but I'll read it to you and you can let me know. Somebody asked, how do you handle divorced parents? Do you have both parents sign initial annual intake paperwork? Very specific question about maybe medical documentation.
That depends. It's going to depend on, in part, what the terms of the divorce decree are and who has what kind of custody. That is one of those very specific, fact-specific inquiries, and I actually get that one a lot. And it seems like every situation is slightly different. So that would be one where I would ask the individual to contact us, because again, it can vary depending on some particular circumstances.
Okay, well that was all the questions we had posted from our listeners. So I'll go ahead and wrap this up. Thank you so much, Heidi, for your plethora of information, and thank you all for joining us. And if you do, think of any questions in the future, you can feel free to reach out to Heidi or the firm at her email address. And we look forward to having you all join us next time. Thank you.
Thank you all for listening, and Happy New Year.
Mm-hmm.